Come on out here, do the stage and then.
Wow.
But thankfully.
Thankfully, they've resolved that amongst themselves.
But yeah, that's typically, that's when I accepted this, oh, okay, I guess I can do it. So you work, so what classes do you teach here?
Federal in Texas.
Okay,
Right now, I'm doing 2 Texases online.
Okay, okay. Yeah, I had 2 federals online last semester, and then we'll see if I was enrollment enough for, I'm supposed to do a late start this semester
Yeah.
in person. We'll see.
Here. Hi, hello. Hi. I am Audrie. Finally.
Yes. Oh, well, goodness, thank you. Hopefully good things.
A wonderful thing. Thank you for coming with Billy, and I know Billy from the summit. So.
Okay.
Yeah, she's already had to suffer me.
Oh, okay, okay.
It was not suffering. He actually saved me because I wasn't quite as prepared for my presentation.
Oh, well, that he may be saving me today.
He very much saved me. I had some family things happen the day before, and I was like, oh. So you're in good hands with Billy. Trust me
Perfect,
on that one.
perfect. I'll let you answer all the hard questions.
Or not.
Did Miranda send them to you in advance?
Yes, we have.
Okay, so you were able to glance at it.
Yes.
Billy, and what I told him was, we were debating whether to ask all of the questions, per category,
Mhm.
but I think it's best to one question for each category and
Yeah,
then loop
that's
back
fine.
around. So we touch upon several topics, I guess. We've got a couple minutes, I think.
You able to get in?
No, my computer just died.
Oh.
It's okay. I was struggling to get it to work. And then it just.
And then it said I have
It said
not.
bye-bye. Yeah, and so I said, well, thankfully I have my phone, I have my notes.
You know,
I've learned to,
the projector is just a mess. And so students will always like had that moment where they thought they were getting out. I was like, no, I know how to do multiple formats.
right, take this sheet of paper.
I come from a day when you had to do poster board because PowerPoint didn't exist.
Okay, yeah. This is, oh goodness, I don't know that answer for somebody at all, this.
Yeah.
Norwegian.
I actually.
Did you have that one?
I have a note on this.
Yay.
which is that it's probably going to relate to issues with the concept of consent as defined by the state. Yeah. When in doubt, just put back to consent.
Right,
That's what the
right.
court does, right?
Well, that's in fact the jockeying between the state.
Miranda, reading these questions, a lot of this, I think, might revolve around what we consider validity.
Right.
So,
Okay.
Ready as
Begin and welcome everybody on behalf of the Department of Political Science. We are grateful and excited that you are here today. I want to begin by thanking some individuals before I introduce our panelists. I would like to thank our Dean, Fay Lee from Division 3 for her support, as well as her staff, which includes Nadia, who's in the audience, and Sierra for all that they do to help these events be possible. I would like to thank Josh, who's in the back, who runs our tech stuff on behalf of these events. He's been with us from the very beginning, and he graciously handles all of the technology and the online chat. I'd like to thank President Jones, who has been a supporter of everything our department does, and Captain Timniak from Campus Security, who helps with these events, as well as the Political Science Club, who will speak to you shortly. So with that said, I'd like to acknowledge the government faculty members in the audience, the department chair, Miranda Ashworth, Daniel Cooper, Maya Shulga, and Mitch Cutzinger, who is our gracious host today. And without his efforts, some of this wouldn't be possible. So thank you. I would like the students to be aware there is a sign-in sheet in the QR code in the back on the table. So please make sure you sign in so your respective professors know that you have attended today. And it was just brought to my attention that they are working on the online chat. Apparently there are some technological issues and they are trying to get it fixed for those who are participating online to be able to ask questions. Just to give you a brief history of how this started and how Village Square started, it actually began last summer. Professor Ashworth and I were sitting in our offices one day and we were just discussing some hot topics that were happening throughout the summer. And the more we discussed them, the more we realized that we needed to have a forum in order to discuss those topics. So it was originally called the Summer Heat Hot Topics in Political Science, and we covered things related to the Second Amendment and the right to bear arms, abortion, book banning, and then of course this past fall, it evolved into the Village Square. So today's event is called, Is It Constitutional? I have looked at some of the questions that have been submitted, and I think it will make for a lively discussion. So before I introduce the panelists, I would like to call up the president of the Political Science Club, who will take a few moments to speak to those of you in the audience about the club. They are co-sponsoring this event, and they have several things happening. So Brian, if you'd like to come up.
Hi, everyone. As you know, I'm Brian Dennis, and I am president of the Poli-Sci Club, or Political Science Club. I just want to take a moment to announce a few things. So starting March 6th, we're going to have our meetings every other Monday. At that meeting, we'll have Chick-fil-A food and drink, so feel free to show up. If you are interested in any kind of political discussion, you're majoring in social sciences, I do recommend and urge that you do go. We'll be a part of events such as this one, including the Crypto Chaos, which takes place in April 13th. So please stop by for that. Beyond that, we also have a flyer in the back. So if you are interested in joining, there is a QR code for you to scan to join our grouping app where we communicate mostly. That's it. Thank you so much.
Thank you. So now I'd like to introduce our two panelists today. The first is Professor Billy Justus. I had the privilege of working with him this summer on the abortion panel. And so a little bit about his background. He has a bachelor's degree in political science from the University of North Carolina, Asheville. And if I remember correctly, I had to distinguish that from the other campuses at UNC, correct?
Yes.
Okay, master's in government analytics from Johns Hopkins University. And he is currently a doctoral student in political science from the University of Houston. His area of study is the political economy of the Supreme Court, with a special focus of how this impacts underrepresented groups. He currently teaches for us here at Lone Star. He has been with us nearly a year. He has published 2 papers with Alex Bates. One looks at the effect of media coverage on how long it takes the court to decide a case. The second one is about how lower courts use shadow docket decisions as precedent. He has a third paper that looks at the public perceptions of judicial fairness based on a judge's wealth. It is currently under review. He is also working on mapping how the Supreme Court's ruling in economics cases impacts income inequality in the United States. So welcome, Billy. Okay, and our second is Professor and Judge Audrie Lawton Evans. She is currently a presiding judge of Harris County Civil Court at Law Number 1. Judge Evans was appointed to her position on August 10, 2021. She also currently serves as the current administrative judge for the Harris County Civil Courts at Law. Judge Evans earned her law degree from Thurgood Marshall School of Law in 2002 and her Bachelor of Arts in History from Loyola University in 1999. In law school, she served as the vice president of her class, a member of the Law Review, and was a first place winner of the 2001-2002 Helen Dawn Williams mock trial competition. Judge Evans began her legal practice at the Office of the Attorney General of Texas as an assistant attorney general in the Civil Litigation Division. After returning home from Austin, Judge Evans served as an assistant disciplinary counsel with the State Bar of Texas and a special prosecutor, the Special Prosecution Unit of Texas. Prior to her appointment, she worked as an assistant general counsel at a local Houston company. In addition to her service on the bench, Judge Evans has given back to the community by volunteering countless hours to various community service organizations. She has also served as a speaker and advocate for implicit bias training in and around the state of Texas. And she is also currently a professor with us here at Lone Star. So welcome, Judge.
Thank you.
Okay, so we are about to begin. And we had asked students and the campus community to submit questions in advance on whether something is considered constitutional. Professor Ashworth categorized these questions into broad headings. So we will begin with the first question. Are government mask mandates in public places constitutional?
All right, so when you say government, that's going to be the first point is which government are you talking about, right? And I think I want to kind of go back a little bit and we talk about this area, right? We talk about constitutional law, and I'll just tell you right now, myself, constitutional law used to be something that it was kind of difficult for me to wrap my mind around it, right? It's a lot of, case law, a lot of laws. A lot of stuff is not very clear when it comes to laws. You would think attorneys or people who, legislators would do a better job of drafting some of these things, but that's not always the case. And so I want you to kind of think about this not from a vacuum, but in the context of our society and how it grows, right? And we are talking about the Constitution, right? And how long ago that was actually put into place. And so what you kind of see over the years, right, is you see a number of things. You see some tensions, right, between state and federal, right? And that's why I say when I ask which government you're talking about, if you're talking about the federal government system, the 10th Amendment, I believe, and I'm going to always look over here to my right for he's the one that's going to be able to tell me if I'm right or not, because he's actively doing this, going through cases as part of his job. And so the 10th Amendment, and I'll let you you can expound upon that, prevents the federal government from issuing and enforcing a national mask mandate, right? But then if you kind of remember, if you look at the news and you remember the news from when the pandemic first started, the states, right? That's where the power lies in enforcing this. And then you kind of even saw some pushback from the counties, different counties around Texas and the state government when they have different views. And then you can even get to, and I think there's another question on here, what does Lone Star require you to do when you come into a class? Can Lone Star make you submit to a mask mandate? So again, as with many areas in constitutional law, the answer is going to be, it depends, right? And it just depends on which context in which you're looking at. Okay.
Yeah,
And Professor Justus, if I may, as a follow-up to that, the next question links to what was just said, but constitutionally, what would be the difference between a mask mandate and the abortion ban? Aren't both governments telling someone what to do with their body?
Yeah, that was a particularly interesting question. It is something that is within that conversations being had, particularly since Dobbs was decided. So I actually want to take a step back because when we talk about this topic, the idea of the government mandate comes with this idea that the federal government actually mandated this, which is we are finding a very common belief among the American public. The federal government itself never mandated masks. The CDC set out a set of guidelines that then states and companies adopted. That is very common in the political realm of things to happen. It is easy to point to the government and say, well, they said we got to do this. And that's what companies did. But actually, it was individual companies, individual states that were actually adopting these guidelines. As to whether the courts would view abortion and mask mandates as even remotely together, the courts are not going to do that. And they're not going to do that for a couple of reasons. Number one, it's very dicey territory for the court. Courts like to be very narrow I'm not going to say all courts. All right. So
Mostly. We're fact checking each other.
yeah. So the Supreme Court particularly likes to issue very narrow decisions. It's very rare that they come out with these sweeping opinions that we hear about. Every year you will hear about 3, 4, on a particularly busy year, 5 cases from the court, but they decide between 80 and 120 cases a year. And you don't hear about most of them because they're these very narrow, very technical decisions. So I don't think that this question is going to get an answer at any time in the scope of the current court. The court's just not going to take it. It's too controversial. They've issued Dobbs and they struck down Roe. So the odds of them ever taking another abortion case is incredibly slim. Simply because they're going to say, we've already talked about this and we're not going to talk about it again. So I know that is sort of a non-answer answer to this question, but I think what I'm really saying here is that from the point of view of the court, this is comparing apples to oranges. And so the court's just not going to engage it. I will also say that this is like I said, it's in the conversation, so it's a pretty common question at this point. And these types of questions, they can be sort of double-edged swords, right? So some people may say, oh, well, we've made this decision about masks being required, therefore we can say that you cannot have an abortion. But that becomes a slippery slope, because at some point we have to draw a limit to what we analogize. And so the court would draw a limit here. They simply wouldn't touch it.
I think though that the question speaks to more of the irony, right, in society, right, and what people use as justifications for which laws they think are good laws and which ones they think are not good, right? And so, yeah, that's a perfect example where on one side you have people who say, you know, my body, I can do what I want with it, right? But you know, if you flip the argument, right, then there is, you know, they're exactly opposite of what their first position, right? And so it just kind of goes to the psychology of society. And as we go through society, the changes in the way folks think and how they vote and which laws they think are good laws and not.
Yeah.
Okay, originally I thought it would work best to ask a question from each of the subheadings, but based on your answers, it makes better sense
To go through them. Yeah.
So
These are all very linked questions.
related to the pandemic and masks. The next question, are vaccine requirements for college students constitutional?
You want to take that?
I will tackle this one. So I'm going to tackle this sort of with two hats. One is that I've really looked into this, and the other is that I used to be, before I went to graduate school, I was a college administrator. So not like super high up, but like these were questions I had to deal with. And the answer pointedly is yes, they can require that you have vaccines. But there is an opt-out option. And that is what permits them to do it. So you can speak to the health services group on your campus, and you can talk to them about your objection and that you would like to object. And then they will have a form for you to fill out that says that you have morally or religiously objected to the vaccine or vaccines. This opposition isn't, the other thing is that this conversation isn't new. Whether or not we can mandate vaccines has been going on for at least all of my life. Because I remember when I was in elementary school, there was vaguely, like I've been told this more than remembered it actually, but there was a debate even then, and that was more than a decade ago. We'll just put it that way. But particularly as we are seeing sort of surges in a more libertarian thinking about what government should and should not do related to these types of things, we are seeing this come back in with more force. The other thing that I will say is that you will likely see, if this were ever like formally challenged and went through the court system, you would likely see a division between public and private schools. Private schools sometimes get to be lumped in with corporations rather than with higher ed from a state level. And when that happens, they tend to have a little more freedom than a state school would have in some areas. So even if it was a situation where a court ruled that a state school could not mandate it, because that's the government mandating it, that may not apply to a private institution. It's doing a lot of work in that sentence. I just want to be clear about that, because it all depends on enforcement mechanisms from the government, like how the government structured that law, and is it tied to funding and all of this. But generally, private schools get a little more leeway than public schools do in these types of considerations.
All right, so the next subheading deals with abortion. The first question, the most recent ruling in the Dobbs decision suggests the High Court found the 14th Amendment did not confer abortion rights under the Due Process Clause and implied right to privacy. However, is it possible that the 13th Amendment offers women reproductive protection under the Freedom from Involuntary Servitude? And did the High Court consider this argument?
Okay, so I'd like to go back. I just want to kind of go and talk more about the Dobbs, I guess, decision, right? And I had some excerpts from the Dobbs decision that I wanted to read to everybody. And it says the majority concluded that the right to abortion was nothing more than a manufactured constitutional right, an abuse of the 14th Amendment's liberty protection, and that the parameters of the 14th Amendment's protection are set by the scope of the rights that existed in 1868 when the amendment was adopted, right? And so we were kind of talking when I sat down and I kind of talked, and again, the framework for today was looking at what were times like then, right? And when you look at when the Constitution was drafted, when the first 10 amendments were drafted, and the 13th and the 14th and the 15th were drafted, what does our world look like now, right? And you kind of brought up something that's interesting. You said abortion was actually a thing back then. Right.
Yep.
Right. And so the court kind of leans on the fact that, hey, it's not really specifically, listed. And so we're not going to go as far as to say, and it brings up another interesting part about when we talked about the tensions, not only between the states and the federal government, but the three branches of power, right? Or of government, right? And so part of what the Dobbs is saying is that the Supreme Court before overreached, right? Overreached and legislated from the bench when they made this connection and tried to say that abortion was a protected right. And so it's interesting. And the other part that's interesting about Dobbs is there's this concept called stare decisis, right, in the law. And it is long recognized that the need to overturn erroneous precedent. So some people ask, like, well, how can they go back and change, right? Are they allowed to do this, right? This concept, and there's certain cases. There's one example of a case like Plessy v. Ferguson, right? The equal, separate but equal. Well, then at some point that was overturned by Brown versus Board of Education, right? And so that's where they had the authority or the ability, that's where they drew that ability to go back to this decision and to overturn it, whether people are like it or not, right? That's kind of where it stands. So that's just to give you just a little bit of context as to why the court said they made this decision. And I don't know how many concurring and dissenting for Dobbs. Yes, it's a lot. Dobbs has a lot.
It's a lot. It was almost. I'm not going to say the number of pages because I'll get it wrong, but it was in excess of any opinion we have received in recent times.
Right.
Yeah.
And so and we talked a little bit about kind of this. The best analogy is kind of like kickball or ping pong. And you'll see where when we talk about the tension between the states and the federal government, where they kind of kick it back, right? And that's kind of what Dobbs is saying, hey, this is a state. Each state will have a right to determine healthcare decisions, right? Mm-hmm.
And I thought this was a particularly excellent question because anytime you bring up an additional legal argument, I'm always interested. And I think, so the question said, is it possible that the 13th Amendment offers? And the short answer to that is, well, yes, anything's possible when it comes to constitutional law. But the difficulty is you have to get 4 justices on the Supreme Court that say they even want to entertain the notion that this is possible. And then you need 5 justices to say, yes, that's the right decision. And with the current makeup of the court, that's not going to happen. like I said, they're probably if they take another abortion case, it's going to be whether or not medication abortions are allowed to be done without you physically going into a doctor's office. That's probably the next abortion case. Beyond that, they're probably not going to take anymore. So this is an excellent question. I think it's something that legal scholars will undoubtedly be rifling through. But at this point, is it possible? Yes. Is it likely? No.
All right, and as a follow-up to that question, could the High Court now be in violation in the Dobbs ruling of the Equal Protection Clause of the 14th Amendment by not allowing the natural equal protection over a private health decision for a woman that would be afforded to a man?
This was another excellent question.
Yeah, it is.
A very excellent question. And so there are a couple of things that I will say. One of the interesting things about the court is that it views itself as never being wrong. And it's not because it's always right. It's not wrong because they're the last stop on the road. Right. Like there's nothing beyond that unless you legislatively change something or you constitutionally amend. Again, given the outcome of this case, I don't think the court will admit that this is something that they were wrong about. But you do bring up whomever submitted the question brought up a very good point about the gender discrimination now between men and women. And I think that this speaks to something that is much larger in the conversation about abortion, which is whether or not the court is actually viewing this about being between men and women, or whether the court is progressing towards the idea of fetal personhood. Because if they are progressing towards the idea of fetal personhood, then they're not concerned about making this decision that impacts women but not men, because their focus is on the idea of fetal personhood, not the idea of the woman who's carrying the child.
But that it brings up the point again of everyone's role here, right? In society, and all of these cases, all of this precedent happens because someone on a local level decided to challenge these things, right? And typically something happened and it was very personal to this person, and maybe they didn't set out to be the seminal case on an issue, but nonetheless, they had the courage to pursue their claim and all the way up to the highest court of the land. And so everyone in here has the ability to do that. And, even the drafter of this question or the previous question, the only way to really test that is, to take it up. So,
yeah.
All right. Is it constitutional for a brain dead woman to be used as a surrogate? This is based on a paper by a Norwegian philosopher originally published in the Journal of Theoretical Medicine and Bioethics, making a case for, quote, whole body gestational donation.
I love how this question gives you an assignment inside of the question. Now you've got to go read the Journal of Theoretical Medicine, which I did not. So I don't know the answer to this particular question.
It happens to be that I have a person for this who studies bioethics. And so he was able to give me some insight to this. None of which, shall I say, was actually helpful in answering the question in the current context. So I really actually spent some time thinking about this question and really thinking about how that may play out in the courts and how the courts may react to this type of question. Particularly since some of you may remember that in the early 2000s, there was a series of court cases related to a lady named Terry Schiavo. And the court did choose to intervene in that particular situation. But so the court does have a history albeit a limited history of intervening in these types of medical situations. That said, this runs into something that the United States Supreme Court has not generally touched, but the state courts have, which is the concept of consent. Can a brain dead woman consent to this? And the answer to that, I think we can all agree, is no. And so you would likely see this litigated within the states rather than on a federal level about this particular issue. And you'll run into those state definitions of consent, which do differ from state to state based on their state rulings. Now, I do want to add this in. If this is not legal advice, this is just something that could be a sort of caveat to this. I believe that if like a woman placed this in her like living will, that she was willing to donate her body for this purpose, and she did that in sound legal mind, then that would be considered consent in most cases. And so it would be permissible in that very narrow circumstance. That's my guess. But this is, thankfully, this has never happened that we know of. So.
Yeah.
All right, the next category of questions deals with national borders and citizenship. Is it constitutional for the federal government to prevent U.S. citizens who are abroad from re-entering the United States? For example, like during the height of the pandemic.
So, I mean, some of these, okay, one, going back, like I've kind of gone to and tried to kind of bring it down to a human level. Most things that you do, right, are constitutional until they're not, right? And so as you are, living your life, as you are following the rules and, going about your daily thing, if it's constitutional until there is a reason, or until either someone challenges, a law, or in this instance, we're looking at the reasons why a government can make you do certain things, right? And so, of course, when you're talking about a pandemic, right, or if you're talking about public safety, there are powers, right, of the government when it comes to public safety that can at times override your personal agenda or things that you personally want to do. So, the answer is that, yes, generally, yes. Right now, what then happens is there may be circumstances, there may be other provisions like, your freedom for religion, or, things that could make it, make there be a conflict between the two. But as a general justification, the answer is that it's yes. Okay, until it's not, right?
That's exactly what I was going to say.
Okay.
One thing that I will kind of slide in here is that when it comes to the Supreme Court and the concepts of citizenship, you will see that the Supreme Court does not really like that question. That they don't like questions about, is a particular person a citizen, or crossing national borders in a particular way? Does this violate the Constitution? Does what the president doing violate? They don't really like to get into the mire of that, because it fluctuates so much between administrations. And so they just often avoid sort of dealing with this by sending it back to those two branches. And they'll say, oh, well, maybe the president didn't, maybe he gave you 30 days instead of 31 days to think about this. So we're going to send it back and he's got to redo it. So you have 31 days. Like, they will find a technical way out in these types of cases. And that's a very strategic move on the part of the court, because they don't want to get involved in some of these issues. They want the political branches to resolve them.
Right. And this speaks to the executive branch a lot, right? This particular section speaks a lot to the executive branch and the powers that they have.
Okay, well, along the same line of what defines a citizen, does birthright citizenship apply to children born in U.S. waters or airspace, so not technically born on American soil, to non-US citizen parents?
I think you have two questions actually built into this one. And the Supreme Court has not answered either of them. So that's sort of where we are at the outset of answering this one. So the first question is whether or not that birthright applies in airspace, which I think the answer is probably no. And whether or not it applies in US waters, I have no clue how the court is very weird about water law. And then the second question, after they decide that, they can then decide whether or not this applies to non-citizens. So the Supreme Court never just wholesale takes it all at once. There's always like a 1-2 with the court. It's very like steady progression, kind of building it, let it sit, see how everyone responded, then take the next step kind of thing. But do you have any insight into that? Because I have no insight beyond that.
Yeah, no.
For this particular question. This is an excellent question, though.
These are all very good questions.
Yeah,
They're
yeah,
very,
these are
very
excellent
particular, and that's why it's kind of hard. Because a lot of this stuff is before the Supreme Court as well.
Yeah,
You know,
some of it is,
some of
yeah.
these things are.
Okay. Is it constitutional to close borders if there is a war in the neighboring country and not allow refugees, especially women and children, to cross the border?
So, I mean, again, that kind of speaks to the executive branch's ability to protect the borders, right? And so, I guess when you insert the word, is it constitutional to close, right, the borders? It's a practice that happens, and the executive branch is the one that can order that, right? And so again, if there's a safety concern, and this question kind of builds that in, right? The question in and of itself says, if there is a war, right, in a neighboring country, right? So that almost lends credence to the idea that if you may have to protect your border in that instance. And so if the government enacted if that was something that the government enacted at the time, I don't see how they would be outside of their purview to do so.
Yeah, I agree entirely. I think that this is something that the courts would permit, and they would say that that was justified within the national security powers of the executive. Given the structure of the question, would that be politically popular? That really depends. I think if the war was in Mexico versus the war being in Canada, we might legitimately have a question of differences of politics there. But on the whole, I think if this is not a word, but media sized enough, right? If the media covered this enough, I don't think the president would have the political capital to shut out women and children who are trying to escape a war zone.
Are people who cross the border illegally entitled to the same protections under the Bill of Rights as American citizens?
Another good question.
Yeah, this one I think has a bit more of a straightforward answer, which generally speaking is yes.
Yeah.
Like anyone who violates laws in the United States on US soil, they have the same protections as US citizens in the court system. Unless they are designated as an enemy combatant.
Which most likely they wouldn't be then out
Yeah.
in general population.
Yeah, they would be general population.
Probably. Right?
Yeah.
Yeah.
Is it constitutional to detain children in cages if their parents cross the border illegally?
Is it inhumane? Yes, right? Yes, it's inhumane. Have we gotten to, the constitutionality of it and decided that? And no, right? We've seen it play out, We've seen it happen, right? And so, again, unfortunately, and this is my opinion, unfortunately, this is a practice that, again, if there is a justifiable reason, right, then those kind of practices can take place. Right?
Yeah. So, in thinking about this question, before I go into this answer, a show of hands, how many of you know what I mean when I say shadow docket? Okay, only a couple of you. All right, so let me define what this is, and then I will explain why that's relevant to this question. So the shadow docket is when the Supreme Court rules on a case without going through the normal procedures. So normally you ask the court to hear the case, the court meets, they debate whether or not they want to take the case. If they take it, they then have this hour to 4 hour, depending on the question, oral argument where lawyers really fight out with the justices what a decision should be come to. Then the justices retire, and within 2 to 9 months, you receive a long legal technical opinion answering that question. Shadow docket doesn't do that. The shadow docket is when the justices are asked to take a case, and then without any filings, any additional filings, any oral argument or anything like that, they issue a formal ruling on the case. Okay, and so because it is not this public event of the oral argument and that combative process, it has been dubbed by a legal scholar the shadow docket. The reason I bring that up is that there was a shadow docket case that dealt with a young lady prior to Dobbs who was seeking an abortion because she had been raped by her father, and she was here illegally. The father crossed the border with her illegally. And during detention, it turned out that she was pregnant and that she had been raped by her father, and her legal advocate were seeking an abortion. And on the shadow docket, the Supreme Court said that she was not entitled to that the state in which she was held could intervene and prevent that from happening. So it does seem that there are moments where, or I'm sorry, it was not the state, it was the federal government. Sorry, I misspoke there. It was the federal government who had intervened to prevent that from occurring. So it does appear that there are some differences, but these are differences that are going to have to be hashed out individually through the legal process. Unfortunately, there's just not going to be a blanket answer to any of them.
All right, shifting focus. The next series of questions focuses on the criminal justice system. So the first question, are DUI checkpoints and Border Patrol checkpoints constitutional?
Okay, so short answer, and I'm sure you have all of the legal history of it, right? The short answer is yes. Okay, all right. And there was a 1990 court case, the U.S. Supreme Court case. It determined that intrusion on individual liberties, i.e. being stopped in a DUI checkpoint, does not violate a person's Fourth Amendment protection from unreasonable searches and seizures. So you start out right with your rights, right? You have this right against or protection against unreasonable search and seizure. And that's going to kind of go into the next two questions, or the first two questions. But again, when we talk about the why or the reason or a justification for it, that becomes something with if you're the Border Patrol, if you can tie it to safety, if you can tie it to there being a reason for it. And it's still challenged a lot today, but the Supreme Court has issued that ruling. And so the answer, of course, is that yes, it's yes. It goes going into the next portion. of it. Well, do you have something you want to add to question one? Okay, question two.
All I had was the word yes.
Yes, okay, he had yes.
Yeah.
I'm talking too much, okay.
No,
All right.
you're good.
Do you want to read the second question then? or-
Right. So the second question, right, it says, when is it constitutional for law enforcement to search your person, car, house, et cetera, without your consent or a warrant, right? And so again, this speaks to this protection that you've got as you're walking, all of us have it right now, and we didn't even know it, right? We've got it. That someone can't just come up to you and just search your person, search your car, search for no reason, right? And so in the criminal context, you'll hear a lot about probable cause, right? And that is what would allow a law enforcement officer to search you, right? And so you kind of think about like, what is probable cause? And I don't know, I'm a civil judge, but when I was practicing as an attorney, I did do some criminal cases. And so some of the most interesting information about this comes through the police report itself, right? And the police know at this point, or law enforcement knows at this point, that they've got to, in their report, they've got to show probable cause, right? And so you would start seeing buzzwords in a police officer's report. Walked upon the vehicle, there was a strong odor, a strong smell of marijuana. Can't tell you how many police reports start off with that exact sentence, right? Because again, they're trying to establish that there's probable cause. There's a lot of case law that goes back and forth about the Fourth Amendment. If you have a contraband, if it's visible, I mean, some stuff is easy, right? If it's visible upon your stop, then the police have every right to search your vehicle. If you got a gun on the console, right, and they can see that. But there's going to be other trickier times, right? With the trunk, or items that might be in your trunk. You generally, on a traffic stop, if you're driving along and you're obeying all of the rules, there really isn't a lot of probable cause to stop you, right? You start swerving, you hit something, you drive too slow, that might be probable cause for the actual stop. And then if they notice something in the commission of the stop that allows them to search your vehicle, i.e. that you have some kind of weapon, drugs, anything like that, that will give them probable cause to actually search the vehicle and your person.
Yeah. The only thing I have to add to that is, generally speaking, the car has a different set of constitutional rights than the house does. And they both have a different set of constitutional rights than the person does. So you could be walking down the street, and if a police officer thinks you look shifty, they could do what's called a Terry search. And that's for their safety and public safety. They can just sort of do, I'm not really familiar completely with the procedure, but sort of somewhat of a pat down to make sure that you don't have a weapon or something on your person. That is not a violation. And as technology has improved, the court has been willing and eager to venture in to things like, can they use infrared technology? Can they use drone technology? Because generally the rule is if it's within public accessibility, then they can sort of do their thing, right? Like if you have a marijuana plant growing on your porch that everyone has access to, the police can walk up and do something about that. But there was a case a few years ago about whether or not the dog could sniff at your front door. A search dog could sniff at your front door. The answer to that is no, they can't, not without a warrant, because the dog's nose is so sensitive, it can reach inside the house, and that is a violation. But very recently, within the last couple of years, the Supreme Court has also ruled that if you get stopped and for a DUI or a suspected DUI, the police can take you to the police station and draw your blood. And that is not a violation. That they can literally stick a needle in your arm and withdraw your blood. Not a violation.
And refusal, you would give up your license.
You give up your license.
Yeah.
So So the court is somewhat all over the place on all three areas, and they're all three treated very separately. And if you look too far into it, you'll hear the word curtilage, which is basically like the boundary line. Where is the boundary drawn? And so for the house, it's the door, the windows, that sort of thing. Because also they cannot use like infrared technology from across the road to like look into your house, because that invades the walls of the house. So.
All right, the next question is,
I think this is our.
is the death penalty constitutional?
Oh, so we're just gonna go there. This one. We're just gonna go there on this one. Okay,
It's not, I mean, it's not, it hasn't been ruled unconstitutional.
yeah, that's the best we can say about that.
Yeah.
So this is a forever question before the court, whether or not this is unconstitutional, whether or not this is constitutional. So one thing that we have to remember about the court is that they approach deciding these cases in a couple of different ways. So you have a group of judges who approach this question sort of like, as society has evolved, do we think that this still meets the contours of the Constitution? And then you have a group of judges who say, well, was it legal when they wrote these words? And was it permissible when they wrote these words? And that particular group is going to win out on the death penalty conversation. They always have, they generally usually will. And so the idea of putting someone to death is not going to be considered cruel because it keeps the public safe, and it's not going to be considered unusual because the human race has an extremely long history of doing it. So from those regards, the court is unlikely to view it that way. Now, that being said, we talk about we talk about the death penalty now, and we talk about lethal injection. That's our go-to method at the moment. But as some of you may know or may have heard, one of the drugs that is used in the cocktail of lethal injection has to be imported, and countries have begun refusing to export that particular drug to the United States because it is used for lethal injection. So we're not able to get that third drug. That third drug is vital within the cocktail for keeping lethal injection humane. And so it isn't there. But something to keep in mind, the United States Supreme Court has never ruled that any particular method is unconstitutional. So there may be state courts that have ruled that, but the United States federal level has never said that a particular method is unconstitutional.
Right. And then, and there was a period of time of this, that the death penalty was abolished or wasn't there. I mean,
Yeah.
right.
Yeah.
And I think in particular, in this particular instance, and there's a case in Furman v. Georgia, when they found that the sentencing procedures in capital cases violated the 8th Amendment, right? Because they were applied in discriminatory ways. And so that was a time in our history where they did pause or stop the death penalty, trying to answer the question of whether or not there was discriminatory practices in sentencing, right? And so you see where they kind of touch on the death penalty in different ways, but you're right, there hasn't been any definitive or any actual rulings.
All right, the next set of questions deals with, actually, the next couple of sets deals with First Amendment issues. And so are book bans in public schools constitutional?
So remember I said the Supreme Court likes to be narrow.
Yeah.
This is where that comes into
Yeah.
play pretty heavily. So there was a case in 1982, and I'll spare you the name because it actually takes up a whole line on a Word document. But there was a case in 1982 where the Supreme Court said that school boards cannot unilaterally ban books because that's the government, and the government cannot violate the First Amendment. Or it's not that they said that they couldn't violate the First Amendment. They said that there were likely credible claims of violating the First Amendment if a government entity were to ban a book. What they said instead was that parents could advocate for the banning of books. So parents can ban books, school boards cannot. And in the year 2000 in the state of Texas, building on that case, there was a case out of Wichita Falls where some parents, there were 300 parents, they wanted to ban a couple of books. One was called Heather Has Two Mommies, and the other was called Daddy's New Roommate. And these 300 parents went to the school board voted to ban those books, and someone sued. And in Texas, that district court ruled that the school board had overstepped its bounds, that it had permitted what it called a heckler's veto of people's right to information. So what effectively came out of that ruling was this idea that you can decide that your child will not have access to this book, but you cannot say no one's child can have access to this book. Now, that's going to apply because that is a district court in Texas. That is going to apply to a very small geographical location. So that's not the rule for the entirety of Texas, for example. It certainly doesn't reach outside of Texas. But in both cases, we're talking about a situation where the courts have upheld a parent's right to control access of information to their child, but not necessarily to other children.
And I think the next two questions are fairly similar. So combining them, is forcing a particular educational guideline or outline unconstitutional? More specifically, are bans on African-American AP courses, like in Florida, constitutional?
It's kind of your same answer, right? Yeah.
So in this particular situation, so I'm going to take the educational guideline outline first, because that is not something that's actually entirely controlled by the federal level. The states have a lot of power over what curriculum looks like within that state. So is it constitutional? Most likely, because the state has the right to set the educational guidelines for its citizens. Banning a specific course, that's going to be a Supreme Court case. Like if it gets there, like if the court chooses to wade into it. Florida currently is running into a lot of these questions because their governor has effectively issued a list of banned books. I mean, that's the government banning books. That's in violation, in theory, of the 1982 ruling. That's going to take a court case for someone to tell him he's actually in violation, right? And I think that the same thing would have to happen with this African-American AP course. But now Florida is kind of considering this idea of getting rid of all AP courses, and that may well just allow Florida to win. Like if they have no AP courses, then they don't have to worry about censoring a particular AP course. They just don't have that option. I will say that would, like, from a college standpoint, I will say that that would be a tremendous disadvantage to the students of Florida in applying to college. So like that's really cutting off your nose to spite your face.
Okay, along the same lines of the First Amendment, related to speech and protesting, what is censorship and is it ever constitutional?
Okay, so censorship, and then we're talking about, I guess, government censorship, right? the government would limit your rights or under the First Amendment for free speech. And so it's been determined that there's a lot, of course, again, like most of these others, a lot of case law concerning what is actually protected free speech. And so there are circumstances, right, where censorship is permissible, right? And it'll kind of boil down to what type of speech or what are you trying to, or the person trying to say? Is it something that's offensive? Is it something that overrides your ability or this right that you generally have? Again, this is another right we generally have and we walk around for free speech. Let's see. I don't have any particular cases that limit it. Did you have any cases on that one?
On censorship generally or hate speech?
On censorship. Because the first question is just about censorship.
Censorship.
Right.
So the second-
Yeah.
Right. And so, yes. Because the second question is, what is hate speech? So again, hate speech may be something that there's ability to censor certain hate speech. You guys kind of see this in real time going on with social media, right? You see Twitter, Instagram, Facebook, have the ability to stop you right in your tracks and to stop you from making certain statements, right? Even though you generally have this right to free speech. I think that's one example in social media.
Yeah.
And that's
That's actually the third. Yeah.
That is the
These
third
three all go
Right.
right together.
Right.
What I will say, the thing about the social media platform, we cannot give you a direct answer in this very second sitting here, but you'll have an answer in June. Because last week, the Supreme Court heard two cases on the ability of social media to censor its users. So now, granted, those were very specific cases and they dealt with terrorism videos, but it's all about content moderation. That's the underlying principle there. So whatever that decision is going to be the driving force behind the answer to this question. So if they permit them to limit these dangerous videos on their sites, then they can, like, the whole point in those videos is expression and language and ideas. So they would, in theory, also be allowed to limit your individual post.
Okay, if the media is knowingly spreading false information, is this considered protected speech?
It's an excellent question.
Ready to
Question.
answer
I'm
this
so
thing.
ready. This was actually a big topic when I taught government this summer. Like, this was a topic we discussed a lot, was about the idea of false information that floats around on various media outlets. So there are a couple of things. On the whole, if you needed to have sort of a short answer to tell someone at Thanksgiving dinner, it's yes, they can do this. But they do this in a very tricky way. So if you are unaware, there are sort of three parent companies that own all the major news organizations in the United States. And from these three major parent companies, you have sort of two branches of news agencies. You have what we will call network news agencies. This is what comes on sort of like, if you don't have cable, you can still access this news network. It's usually what comes on after your local news has ended. It's, the Dan Rathers and the Tom Brokaws that show my age. And so I don't know who does them anymore. And then the other side is the political news side. Well, that political news side is all opinion-based, and that's what protects them. They can go to court and they can say, it's my opinion. That's why I'm on the cable side, because it's my opinion. And we actually recently saw a variety of situations like that. It's like OAN or News Max or something like that. The news agencies that have sort of built up in the wake of the Trump presidency, they actually sued both commentators on Fox News and MSNBC for the way that those commentators were talking about these newer agencies. And the way in which those commentators had those cases thrown out of court was to say, it's my opinion. I'm an opinion person. That's why I'm on the cable side. And the judges threw out all those cases because they're protected with that. Now, I do want to give you now the history of this, because I think this history is very important. So back in the 60s, back in the days of Walter Cronkite, the FCC developed this thing called the Fairness Doctrine. And the idea of the Fairness Doctrine was that you would have to give equal billing to two opinions on a topic. In 1969, the United States Supreme Court said that was completely constitutional. You could require that. In the 1980s, under the Reagan administration's push to deregulate some areas, their commissioner of the FCC struck this particular rule. So they struck the Fairness Doctrine. And this did not sit well with the American people, and it did not sit well with Congress that this had been struck. And so Congress in 1987 passed a law that would have enshrined the Fairness Doctrine. That law was subsequently vetoed by Ronald Reagan, who said that there were concerns it would violate the First Amendment. And no Congress has ever tried to pass the law since, even though it had an outrageous amount of support. They didn't even try to override the veto. And so that's where it stands. Yes, news agencies can provide misinformation. It gets trickier though, because there are libel laws, so they can't just print something, and there are slander laws. They can't just say something that is meant to be malicious and intentionally harmful, but you got to prove that. And that's where it gets difficult, is proving that
It's
intent.
difficult to prove, yeah.
So.
All right, the next set of questions focuses, oh, wait, I'm sorry, there's one more.
I got this one. I got this
I ain't
one.
touching this. I'm not touching
I got this one, yeah.
Related to speech and protest. Are the people who invaded the Capitol on January 6th protected by the First Amendment in their right to assemble and protest?
Right, okay. All right, so I got a good quote by Ken Paulson here, and it says, when the barricades fell, so did First Amendment protection, right? And so that's in a nutshell. The answer to the question is some of them, right? Because some people, right, did not go and go inside of the building, did not storm, the Capitol. There may have been protesters, as long as they were, and I think the word is, it's under the First Amendment, and it's the ability to the right of peaceable assembly. Okay. And so again, once it went from being peaceable to something else, then they are not protected, and it is they're not protected under the Constitution, and that's the answer.
Yeah.
All right, now shifting focus to the LGBTQ plus issues. The next question, which has a secondary question embedded within it. Are bans on trans healthcare constitutional? More specifically, bans on hormone therapy for minors. Is that constitutional?
This whole section.
Section,
Yes,
y'all went there.
this is tough. Yeah, this whole section, and some of it's going to be revisited. I mean.
Yeah, it is. So
It has yet to rule, or there's.
yeah, so currently the court has not ruled one way or the other when it comes to this particular issue. I will say, in the wake of Dobbs, with the reliance on historical practice that was sort of enshrined into the Dobbs decision, I'm going to say that I'm going to very comfortably walk onto a limb to say, I don't think the court would say it's constitutionally protected. That if that's something your state permits, then that's fine. But you know what? They weren't doing this back in 1700s or in the 1800s. So that's not something that this covers, according to the logic in Dobbs.
Yeah. And to that note, that's where when the decision came down, and then you can even see, I believe there was even noted by some of the justices themselves that what's next, right? They're going to go back, they're going to revisit some of these others with that same argument that in those cases, did the Supreme Court overreach or, at that point and legislate and find or say something that's a right that maybe wasn't a right under the Constitution.
And just to add on to that a bit, and to move back momentarily to that abortion issue, one thing that's important to think about with this is that the court doesn't just throw an opinion out there and then that's it, right? Like subsequent opinions, even if they're not necessarily related to this one, are going to build on it. And so Roe at its core, if you read Roe v. Wade itself, at its core, it says you as an individual have a right to privacy when it comes to decisions for your medical health care that you have made with your doctor. That is the actual decision in Roe. There is a concurring, so a justice wanted to say more. And so he filed an extra opinion where he said, this is about the right of the woman to choose. And in 1996, is that Casey?
Casey was 92.
Yeah.
Okay. In 1992, that idea of the woman's choice was enshrined in Casey. So when they're striking down Roe, what they're actually going back and striking down is this privacy you have with your doctor. And if they're striking that down, then the decision to have trans healthcare, it's hard to see that protected when it wasn't something that was protected in 1789 or 1867. And it's not something that's enshrined now. But we have a lot of medical opinions that say this, and they all went back to Roe, because when Roe was decided, the core concepts in Roe were decided 8-1. The entire case is 7-2. Like, it was not a controversial decision on the court. It did not become controversial until interest groups got involved. And in fact, the day it was decided, it wasn't even on the front page of the paper. So on balance, it was not on the front page of the paper because President Johnson had died that day. So it was pushed back because of the president's death. But it wasn't a controversial decision. But a lot of subsequent decisions are sort of structured on this idea that you have a privacy to your doctor. That was the core central idea of Roe. And so without Roe, these types of questions become on shaky ground.
And I think, I don't know if you want to comment on the next question, but I think you somewhat covered the answer to that question related to marriage equality and whether that is revoking marriage equality constitutional.
Yes, because the Supreme Court has the right of judicial review and it can change its mind.
Okay. And then if an LGBTQ couple is unmarried, but meet the definition of a common law married, if one of them were to die, would their property / benefits go to their spouse or to their next of kin?
Oh, that's interesting.
I have no expertise in this. So.
Yeah, that's interesting. I mean, first, common law marriage is an interesting concept. I've had in my 20 years of practicing, I actually had a case that was a common law case. And so the things that you have to prove in a common law marriage situation maybe are a little bit different than the regular divorce, even, it would require that the movement would have to assert common law. I don't know that this has been done. I assume it may have, or there may have been, an attempt at this, but I don't know that there's an answer to this question. Because I don't think I know it hasn't gone up to the Supreme Court.
It has not gone up to the court. Yeah, it would be argue out.
Out of probate, yes. Mhm.
And my thought on it, like my 1-2 cents of it, is that common law is defined by the state in which you're in. So I imagine that it is not a Supreme Court decision that will determine this. It's a state Supreme Court decision that would ultimately rule on that.
Correct.
All right. Shifting focus once again, related to the Second Amendment and the right to bear arms.
Yes.
How does the U.S. Supreme Court decide which regulations on firearms are considered constitutional and which ones are considered an infringement on the Second Amendment?
2 years ago, I'd have a completely different answer to this question than I do now. And then goodness, like 20 years ago, it would have had a different answer than we do now. So it used to be that gun regulations were just an understood feature of law, that they just existed. And then in 2008, we got the Heller decision that told us that, I believe it was 2008. I could be wrong about the year, but the Heller decision tells us that we have the right to own a gun for self-defense purposes. Then we have, shortly after that, another decision that says cities cannot stop you from owning a gun within their city limits, with very few exceptions to that. And then recently, we got what is called the Bruin decision. Now, those first two decisions I mentioned, a lot of what they root themselves in is this idea of the militia, that the militia was meant for self-defense purposes, and therefore you have the right to self-defense. Bruin just went in a completely different way of deciding things. So this particular case came out of New York, and it was whether or not you could be required to show cause for asking for a gun permit. And the government, like showing calls being something like, that there is a threat against you, et cetera. And so the way the Supreme Court answered this question was to say, well, in the history of the United States, we have never required this before. So no, you can't do that because history is important with this. And so there is no longer a consensus of how you decide this, because some judges want to rely on this idea of self-defense and militia, and some judges are now going back to this idea of history. In fact, we have it's either a district judge or a circuit court that has paused a case because they have hired a historian to go back and look at the facts of this case to determine whether or not the legal ruling would meet the historical record. So effectively, we now have historians as judges as a result of this, because no offense to anyone who went to law school, lawyers are not they're not historians. That their training is in understanding the history of the law, but not understanding necessarily the history in which that law was created. And so all this is to say, there is no longer a straightforward way in which these decisions are made. It's kind of like, okay, what does the history say, and do we accept that history? Which is a completely different thing, because like all fields, historians don't necessarily agree on every facet of what played out in history. So
We have one more question in that category. Would it be constitutional to hold parents responsible if a minor commits a crime with the parent's firearm?
Yeah, so I mean, So a lot of these, again, are some state, these are state laws, right? And I think you've seen recently that, and I think there was a case recently where two parents have been charged with I think their son went and opened, I can't remember exactly where he was, but they are being charged. I mean, and most of the time, and even in most states' laws, there are some provisions, in tort law and that if your child does something, right? I mean, we even have stuff, if your dog injures someone, you could possibly, as a dog owner, be held liable, right? And so the same, it'll depend upon the state, right? There are cap laws and laws specifically as to the requirement that you have to store your gun in a safe way, right? In a safe place. I believe as of right now, there's 29 states that have adopted these kind of cap laws. As with a lot of these issues, what you have is it's kind of confusing, right? Because you have the state level, whatever state that you're in, and then you have the federal government, and the federal government tries to put regulations in there in the mix. And so you could be in a situation where in one state, if you combine the state rules and the federal rules, could be completely different outcome than another state, right? Because they fluctuate. You also have, I think it's really interesting now with guns, the ability to use the internet to order pieces, right, of guns, right? So you may have a gun that at first passes the smell test, and then you go and you can order off of Amazon or Walmart, a silencer or, something that will change that gun into a different type of gun. And so then you've got the issue of interstate or intrastate commerce. It's a lot of different moving parts when it comes to regulations for guns.
All right, what I would like to do now, we have one remaining category, has a miscellaneous category with about 7 questions. And it's my understanding, Josh, with the online chat, are there still?
It's not working.
Okay, unfortunately, those who are participating online.
No more questions. These are a lot of questions, y'all. Like no more.
At this point, but hopefully they can continue. We have approximately 5 to 6 minutes. So I am going to leave the miscellaneous category up to the 2 panelists to perhaps choose 1 or 2 of those questions they would like to focus on that they think they could answer.
So the answer to question 1, and I'll read out question 1, is it constitutional to allow a person charged with or convicted of crimes to run for or serve in office? Okay, so that again will come down to the states, right? To the states. And the answer is, as far as someone who has been convicted, and I don't know the magic words, it's kind of like if they serve their time and they go through it's a process, I can't think of the name of it, but it's kind of like you've satisfied all of your conditions, right? Then you may remember in, I think it was 2020, we actually had someone who ran for city council who had previously been convicted of a felony. And she was allowed, they actually had there was a contest between the candidates. She was actually the number 2 vote getter. And then there was a contest, and the number 3 vote getter asserted this and said, well, she should not have been allowed to run because she had a conviction, but it boiled down to, in this case went to court, it boiled down to her satisfying the other conditions. So she had gone through this process to satisfy these conditions with her post-release conditions. And she was held that she was able to run for office. So we have an actual example of that right here in Harris County.
So I'm choosing to wade into this. I'm actually going to answer the question, is student loan forgiveness constitutional?
Okay, that's a good one. I say yes.
I think everyone with student loans says yes.
I say yes.
So I will tell you that we will have an answer to that in June. This week, actually, a couple of days ago, the Supreme Court heard a case on Biden canceling student loans. I'm here to tell you, like, just look up the top line response to that case. Don't try to get into it because it really revolved around a couple of very technical terms in a law. But I will say also that the reason that case exists is because the president is using a law from 2003 called the HEROES Act to cancel the debt, citing that we were in a national emergency with the pandemic. He invoked these national emergency powers and said that he can cancel that debt. And that's what's being debated. Can he do that? But the Constitution grants the power to the president to control debts owed to the United States. So if he had option to use the constitutional wording instead of using the statutory wording, I think the answer to this may be yes. Because these are debts that are owed to the federal government, even though they are processed through private lenders. And so the answer may well be yes, because the president has control over that. Now, the next question is whether or not free access to college is constitutional. And the answer to that is yes, because if the government chooses to pay for something, we as the taxpayers do not have a constitutional right to sue them for that decision. So yeah, sure, if the government decided that free access to college was going to be their thing, they have a right to do that. And then last is universal health care constitutional. Same thing. The federal government has the right to pay for things that it deems necessary for the people. We do not have a right to sue over that. Now, I will say insurance companies will sue if that were ever a thing. And that would be permissible because they will be what's called injured by that law. So they will have what is called standing to make that suit. But at the end of the day, every country that has universal health care also has insurance companies. They don't make insurance companies illegal as part of universal health care. They simply change the functions of those entities with health care. And because they would not cease to exist, they would likely not win their case. So the answer to all three of those is yes, they should be constitutional.
Okay, and I think that about concludes the end of this presentation. There were a couple of questions, unfortunately, in that miscellaneous category. We just couldn't quite get to due to time, but hopefully we can hold those questions over to another session. I would like to thank both of our panelists greatly for their time today, Judge Audrie, Lawton, Evans.
Thank you.
And Professor Billy Justus for being present with us today. We'd like to thank all of you for attending. If you are a student, please remember to sign in or scan the code so your instructor knows you attended today's session. And that will conclude our event. Thank you.
Thank you. Good work. I know.
That was a lot of work.
You did more work than me. Thank you.
That was like a Spartan race.
Yeah.